I'm the president. My name is Brandon Sargent. I'm glad you're all here. We're very honored to have two esteemed speakers on this very controversial topic, U.S. v. Heller, which was handed down by the Supreme Court this past summer. For those of you who don't know the Federalist Society and what it does, it's a nonpartisan, conservative, libertarian organization dedicated to fostering balance and open debate about fundamental principles of freedom, federalism, and judicial restraint. And just to introduce our two speakers, we have Ray Diamond here to our right, professor at Tulane. I had the pleasure as a first year him teaching me criminal law. He's currently right now at LSU as a visiting professor. And as we all know, our ACJ professor and our criminal law professor, Steve Singer here, will also speaking as well. Our format will be probably about 20-25 minutes for Professor Diamond, and then followed by 15 to 20 minutes from Professor Singer, and then we'll open the floor up to everyone, Q&A for both of our speakers. So without further ado, we'll begin, and we'll begin with Professor Diamond. So thank you guys for being here.
Well, thank you. My thanks to Mr. Sargent for inviting me here. It was only a couple of years ago that I used to call on him, but now he's called on me, and of course the worm has turned. I also want to thank Mr. Sargent and the Federalist Society for bringing me back here to Loyola. Whenever I come here, it seems like coming back home. I didn't go to law school here, but I did study for the bar exam at Loyola. I could still find you the spot on the 4th floor in the library in the old building where I used to study. And of course, I've taught some of you, Mr. Sargent, among them a couple of years ago. So I feel very much at home here, and again, thank you for bringing me home. Now, our topic today is Heller versus the District of Columbia. The District of Columbia versus Heller, and the Second Amendment. And very often, the Federalist Society couches these discussions as a debate. But I like to think that Steve Singer, whom I've known since he's come here to New Orleans, is a reasonable man. So we will not be debating so much as we will have a colloquy. So since we're not having a debate, what I want to present to you, however, is a debate about the meaning of the Second Amendment and about the utility of an armed society. And I think that debate can be seen, best of all, in the differing treatments of the story that H.G. Wells told in The War of the Worlds. I like to think about what I'm going to talk about, therefore, as a war of world views. Take just a moment and think about The War of the Worlds. This is a novel written by H.G. Wells in 1898. The protagonist in The War of the Worlds is a man who, having been victimized by alien Martians who have come to London, this man evacuates, like many others, from London. One of the things that he does when he evacuates from London is he takes his gun, his handgun. Eventually, as the story goes on, one of the things that happens is that the protagonist is able to help a woman who was the victim of a rape attempt. The novel goes on to talk about the demise of the aliens. What's important for our purposes here is that this novel, written in England, and written in England before England effectively ended the right to bear arms. And this was done largely as a reaction, though not solely as a reaction, to concerns about the Irish. This was written, again, in the late 19th century, before England had effectively rid itself of the right to bear arms. Now, contrast that with the most recent iteration of the story of the War of the Worlds. It's in the Steven Spielberg movie by the same title, The War of the Worlds. It's from 2005. You'll recall, many of you will have seen this movie, that Tom Cruise is the protagonist. He evacuates another major city, it's New York. He's evacuated the city because the aliens have come to town. Among the things that he does is he takes his gun. We found out in short order that Tom Cruise is not competent to use this gun because someone steals it from him. The gun is stolen by another who uses it with criminal intent and to the disorder of society. There's another character, Tim Robbins, one of my favorite actors. I saw him in The Shawshank Redemption. He was great there. In this movie, he's another person who is trying to survive the aliens. He too has a gun, and it turns out that he's off his rocker. Unlike in the book, where the military has limited success in opposing the aliens, in the movie, the military has guns, but to no effect. Everyone in this movie who is armed is either incompetent, criminal, insane, or just plain ineffectual. And survival in this movie, unlike the book, is not a matter of individual effort or self-reliance, nor, to borrow terminology from A. Philip Randolph, are there possibilities of salvation that emerge from collective endeavor. No, in this movie, survival, personal security, is simply a matter of luck. Now, this classic novel of H.G. Wells, when juxtaposed to the newest film rendition then, illustrates what I call a war of worldviews about the utility of firearms and about the utility of having an armed society. One is tempted to suggest that this conflict of views is a conflict between government and individuals, with government intent on providing safety for its citizens, to the point of disarming them, as though government does not trust its citizens. Individuals, on the other hand, heir to the sense of rugged individualism that conquered a continent, cleave to their right to be armed. But to see this conflict of worldviews as simply between government and citizen would not be entirely correct. Many individuals are armed. There are more firearms than people in this country, and half the households in this country are armed. The National Rifle Association is one of the largest, if not the largest, civil rights organization in the United States. Remember, however, that it is only half of the households in the U.S. which are armed. By this, I do not mean to put what some might say is the altogether reasonable question of what's wrong with the other half, but instead to offer that this means that many individuals are not armed, and some of them have joined organizations such as Handgun Control Incorporated, organizations that would have it that both as individuals and as a collective, we as citizens would be better off without any of us being armed, and that government should be trusted to disarm us. But it's not just individuals who take such a jaundiced view of the right to bear arms. Some state governments, such as California and New York, do so as well. Others, Louisiana and Florida come to mind, are quite tolerant in their constitutions and laws of the citizens' interest in, and in over 30 of the state constitutions, their constitutional right to bear arms. But while there are states which are tolerant, there are local governments which are quite hostile. Chicago is a fine example. Along with Washington, D.C., Chicago had the most stringent gun control measure in the country before District of Columbia versus Heller. which invalidated gun control regulations in the District of Columbia. Regulations that amount in both jurisdictions to prohibitions on the keeping or bearing of firearms for any useful purpose, including self-protection. Another fine example, and one that I think we will resonate with, is the reaction of the New Orleans Police Department in the immediate post-Hurricane Katrina time period. You will recall that there were individuals who stayed in the city. Many of them were in fact high and dry, but even for those who weren't, they were in their own homes for the most part. They were armed. They were minding their own business, and when the police recognized that they were armed, the police, A, arrested them, and B, confiscated their weapons. Now, what's very interesting about what happened with the police, and again, I'm saying this to illustrate once again that there's a difference in worldview here, and then I'm going to put this together with Heller and tell us how Heller fits into this picture. What we see in the New Orleans Police Department is an extreme version of the suggestion that the citizen has absolutely no right being armed, that arms only endanger others. The only people who need to have arms are the police, and they need to have arms in order to protect the rest of us from the bad guys. The position of the New Orleans Police Department then is that there should be a duopoly of force, that the only people with weapons are criminals and the police. And we, the regulated citizenry, are at the mercy, therefore, of the police to protect us from the criminals. This is not the position that the Louisiana courts took. It is not the position that the Louisiana Constitution takes. It's certainly not the position that the Louisiana legislature took, for the Louisiana legislature passed a law confirming the right of individuals, even in times of disaster, to maintain their weapons, at least in their own homes, and when not using them for any criminal purpose. Some 8 legislatures of other states, in response to what happened in New Orleans, have passed similar statutes. Indeed, the Congress of the United States has passed a statute to the same effect. Once again, there are, in fact, 2 worldviews about the virtue of being an armed society. One of them takes it that it is no virtue at all, but that it is a positive vice. The other one takes it that this right be spoken not only in the Second Amendment, but also in the constitutions of many of our states, and in the practice of so many individuals, that this right is a matter of civic virtue and one which should not be denied the citizenry without an extraordinarily good reason. So again, where does this right to keep and bear arms, where does the Second Amendment, where does Heller come into this discussion? What relevance does this remnant, this Second Amendment, this remnant of 17th century English Whiggery and have on the mean streets of our increasingly dangerous cities of the 21st century? To answer that, it is necessary to back up and say a word about the Second Amendment, and the quality of the debate over the Second Amendment, and the direction that that debate should take in the future, given what has happened in Heller. The Second Amendment debate has, of course, been an inescapable feature of American public life for the better part of a generation. An integral part of the often acrimonious national debate over gun control, the constitutional provision which reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." This Second Amendment has been subject to 2 instrumental interpretations by partisans on different sides of the gun control debate. And as you'll see, these different sides, I think, cleave very much to the distinction that we've made between H.G. Wells' War of the World as a novel and The War of the Worlds as a movie. Proponents of stricter gun controls have tended to stress the amendment's first clause, arguing that the Second Amendment was designed to protect the rights of the states to maintain militias free of potential encroachment by the newly formed and feared federal government. We'll call this the collective rights view. Opponents of stricter gun control, advocates of the individual rights view, have argued the opposite. They stress the provision's second clause, arguing that the mere mention of a well-regulated militia should be viewed as an amplifying rather than a qualifying clause. That is, that maintaining a militia of the whole citizenry armed with privately owned weapons was but one reason for securing the people's right to arms, that the amendment was also designed to secure the citizens' right to arms for private as well as for public purposes. Now, I would like to urge a new debate or discussion concerning the Second Amendment. In my view, the debate over the collective rights theory, at least in its most simplistic form, is not worth having. Little in the history, the statements of contemporary commentators, the text of the amendment, or the even scant treatment of the amendment before Heller, and certainly the treatment of the amendment in Heller, justifies the view that the Second Amendment was simply meant to safeguard an individual, or rather to safeguard simply a collective right to arms. When the history of the 14th Amendment is added to our considerations, the view that the Constitution was not meant to protect a right to an individual right to arms becomes totally insupportable, a result of result-oriented constitutional denial that can be, and that was in Heller, readily dismissed. The realization that the individual rights theorists have essentially been more accurate than their collective rights adversaries, however, should not be the end of the Second Amendment debate, and certainly Heller would not have it that way. Justice Scalia's argument, in fact, adopts the collectivist view, it adopts the individualist view of the Second Amendment. It rejects the collective rights view of the Second Amendment. And for that reason, what Justice Scalia did for the majority was to reject the notion that a complete prohibition, a complete ban, effective ban on the holding of arms in the District of Columbia, even for purposes of self-protection. He rejected the notion that such a ban was within the Second Amendment right. What he did not do, however, was to parse the test that we would use in the future to test other gun control regulations by the federal government. Moreover, what Justice Scalia did not do was to state whether the Second Amendment right would be incorporated as against the states under the Due Process Clause of the 14th Amendment. He does make, at least in two places, I think a very interesting invitation to those who litigate these matters to bring such matters before the federal courts. The last time the Supreme Court entertained a Second Amendment case was 1938 or 39, U.S. versus Miller. Justice Scalia, I think, quite clearly hinted at us that the court is very willing to take on cases about the right to bear arms in the future. I do believe that cases such as those involving Chicago, because there are those who have challenged the Chicago regulations. Mayor Daley in Chicago, not the first one, the current one. Mayor Daley in Chicago has served notice that he intends to defend Chicago's gun control ordinances to the hilt. And so I think that we can look for litigation on this matter to make its way through the courts and potentially up to the Supreme Court. So what I do believe is that the debate over the Second Amendment right so far has been limited in some very large measure to the question of whether it's an individual right or a collective right. Individuals who are capable of owning and keeping firearms are only the collective, such that individuals like the individuals in the National Guard would be able to keep and bear arms. I think that has been resolved by Heller. what again hasn't been resolved by Heller, is the test that the courts will utilize in order to weigh the individual right of the citizen to keep and bear arms against the legitimate and sometimes weighty interest of government in crime control and public safety and the like. Now, once again, I do believe that more sophisticated students of the Second Amendment from both the collective and the individual rights schools recognize that any understanding of the amendment as being concerned purely with the militia for military purposes or solely with the individual right to bear arms is woefully inadequate. Instead, properly understood, the Second Amendment has much to say concerning the citizens' rights and obligations, the balance of power between the people and the state, and a connection between a people's courage on the one hand and their ability to live in security and freedom on the other. Briefly put, the Second Amendment should be seen within the context of a Republican political theory, small r, not large, that saw both citizen virtue and citizen participation as essential to preserving the liberties of the community. The militia of the whole envisioned in the Second Amendment was to be valued not merely for its contribution to the defense of the state, but as its very language stated, that of a free state. Participation by all would prevent the development of a separate arms-bearing caste, a caste that would view its interest as distinct from those of the citizenry at large, a caste that might one day be used against the very people they were enlisted to protect. So widespread was this view concerning the political value of the militia at large that even that advocate of a strong central power, Alexander Hamilton, who, by the way, thought very little of the military value of the militia of the whole, Alexander Hamilton advocated arming the people at large and requiring them to show up once or twice a year and demonstrate a minimum proficiency with their weapons. But if the militia and the armed citizenry were seen as servicing an important political function, they were also viewed, and this might be more important for our purposes, as serving an important related moral function. The Second Amendment is in part a moral statement. The people, this is the moral statement of the Second Amendment, the people are courageous and self-reliant, having, as Madison put it in Federalist 46, the advantage of being armed. They, the American people, are not like the dependent peoples of Europe who are forced to rely on the state for protection. Instead, they are capable of defending themselves, the state, and their liberties against potential governmental usurpation. This Republican preference for the courageous, self-reliant citizen capable of playing a role in his own or her own defense and the defense of the community stands at sharp variance with many of the presumptions of the late 20th and early 21st urban American culture. The Second Amendment debate is really less a debate about constitutional interpretation or historical meaning, and more a cultural clash between those who, however imperfectly they express it, seek to preserve the Republican values of the framers, and those who quite consciously reject those values. This can be readily seen in much of the debate, both over the Second Amendment and gun control more generally. The value of an armed citizenry for community defense is seen as anachronistic in the light of the professionalization of the military and police forces. The armed citizen is seen as feckless at best, or worse yet, a potential vigilante ready to plunge the nation back into its own dark age of lynch law and mob justice. The sturdy Republican citizen envisioned by the framers has been replaced by one seen as incapable of his or her own defense, and one who would wreck the civil order if the citizen tried. All of this has led to a situation radically different from that which was contemplated by the framers of the Second Amendment. In place of the partnership that was meant to come with universal participation in the community's defense has come a dependent reliance on a separate caste for the citizens' very survival that the framers feared. In all too many urban areas in particular, the courageous citizenry, capable of both self and community defense, has been replaced by a fearful population cringing before what the nation writer Christopher Hinkins has aptly called the duopoly of force possessed by the police and the professional criminals. This dependency, of course, helps exacerbate the distance between the police and the community. Police and the communities they serve are not partners, no matter how hard public relations officers attached to police departments try to sell that idea. Police officers realize they are a group apart. Even under the best of circumstances, their priorities and those of the communities they serve diverge. In middle-class communities with relatively low crime rates and populations that are able to articulate their political needs, that divergence can still yield some unfortunate results. In inner-city ghettos, when the added difficulties of race, class, and political powerlessness are added to the mixture, the results are often far worse. And here, then, we see, on the one hand, the interest of the community at large of government in limiting access to arms because of the divergence between the regulated citizenry and the police, because of the distrust of the police and government at large of the citizen. Because of this, we have a real conflict. And this particular attitude, number one, and again, this is what Scalia has not told us about. This is what Scalia has invited discussion on. Justice Scalia leaves it to us to develop and to argue to him so that he and his compatriots can decide what the standard will be by which we balance the interest of the government and the rights of the individual. The worldview that has it that the armed citizen is dangerous, of course, would undertake that balance would undertake that balance by weighing most heavily the government's interest. What Scalia hasn't told us as well is whether this Second Amendment will be incorporated as against the states. And those who look upon the individual citizen as feckless will hold to the notion that the Second Amendment should be limited to the federal government. The worldview that has it, as H.G. Wells had it, that there is value in being armed, that citizens who are armed can be virtuous, and that citizens who are armed should be presumed without more to be virtuous. Those who would cleave to that view, just as they would cleave to an individual rights viewpoint on the Second Amendment, would also hold that this Second Amendment right is fundamental. And I hope to address that in the question and answer period. They would also hold that this right should be balanced, favoring the interest of the armed citizen. So thank you very much, and with that I'll leave it to Professor Singer.
Thank you, Professor Diamond. It's a pleasure to be up here. Undeserving I am to be Professor Diamond on this particular subject. However, I will try and contribute some comments. I'm not going to go as long as Professor Diamond because I apologize if you can't hear me. My voice is, I'm losing my voice because I'm a little under the weather. I wanted to start by also thanking the Federalist Society for having this kind of a forum. And one of the things I do in all my classes for those students who have had me before, and one of the things I like about these kind of forums is at the beginning of my class, I always say there are sort of two schools of thought on teaching, on professors, on academia, and making these kinds of presentations. One is you just pretend to be you just are the neutral professor, you don't have a political viewpoint, you don't have a particular viewpoint, and you try and walk the line neutrally and be just sort of giving the law to the students. Or the second is a full disclosure. I land on the full disclosure side, and I think that it was very good, like, for example, the introduction on what the Federalist Society is. We're a conservative libertarian group. It's a full disclosure approach rather than trying to pretend we don't have a viewpoint. As most of you know, I've been a lifelong public defender, and that's sort of, which provides sort of an interesting viewpoint, and creates a tension and a conflict similar to but different than what Professor Diamond described internally for me. Because on the one hand, I tend to be very liberal. Most people in the current late 20th century, early 21st century liberal scheme of things tend to be in favor of gun control, tend to view an armed citizenry as dangerous, whereas it tends to be a sort of more conservative, or to the right, or Republican large R viewpoint, more towards individual rights, anti-gun control, pro and individual rights perspective on the Second Amendment. I come right down the middle because I have that liberal perspective, but I also come at it from being a public defender. I was a public defender in the district. I grew up in Chicago, lived with the first Mayor Daley. My family still lives there under the second Mayor Daley. I was a public defender in the District of Columbia and defended many, literally hundreds of illegal gun possession cases myself. And I've been here in Orleans Parish since pre-Katrina, was here during the immediate aftermath of Katrina when we had the police department seizing guns. So I've actually participated and lived through a number of these different experiences in it, so I think I have a different perspective on that. The first thing I do want to touch on, because I think it is important, is I do think that the District of Columbia versus Heller does illustrate something about jurisprudentially and about jurisprudential analysis. I think one of the things it does demonstrate very graphically is the limits, are the limits on a textual analysis and a plain meaning interpretation of the Constitution and statutory law. And I know that that might be, to some extent, heresy in this particular forum, but sometimes a little heresy is good to create debate and interesting discussion. What you get in DC versus Heller is about 63 pages long, if you print it out from Lexis. And you get, on both sides, you get about an equal amount, a good 30 pages of textual analysis of the, quote, plain meaning of the words of the Second Amendment. And you get 5 justices saying the plain meaning is one thing, and 5 justices saying the plain meaning is the opposite, or 4 justices saying the plain meaning is the opposite. And both are extensive, exhaustive reviews of the language and dictionaries and other statutes at the time in history. And it's hard to see what could be plainer than that the plain meaning is anything but plain from reading District of Columbia versus Heller. And my guess is if you added up the constitutional scholars on either point and the judges and justices on either point in state and federal courts, you'd probably get something pretty close to 5 to 4, or 4.5 to 4.5, or like Bush versus Gore in the election and the opinion, which is pretty evenly divided, which suggests to me that a pure textual plain meaning analysis, while useful and necessary, cannot be the end-all and be-all of either constitutional or statutory interpretation. It demonstrates the weakness in it. One of the things that Justice Scalia, who's a primary proponent of a textual and historical analysis of the plain meaning of statutes and the Constitution, one of the things he says in another opinion of his, Crawford versus Washington, which I agree with wholeheartedly and like very much. Crawford versus Washington is a Sixth Amendment Confrontation Clause analysis. And he starts out by saying the fact that a historical or textual analysis is hard does not mean we don't have an obligation to do it. Just because it's hard or might not come out as clearly as we would like doesn't mean we don't have an obligation to do it. And I agree with that. But however, the acknowledgement that it is hard and may not come out, we might not always get it right, while it doesn't relieve us of the obligation to do it, it also suggests that that can't be the end of the analysis. There must be something more to the analysis than just that. And indeed, I think that in reading, I just reread it, the opinion, 63 pages over the course of the last hour, and I was struck by the fact that the idea that there is an original intent, either of the Constitution or of statutory law or of legislation, either at the federal or at the state level, is not, to me, is not consonant with reality. We all are aware, certainly those who belong to the Federalist Society and like to study the history of the creation of the Constitution, know that there were debates, there was disagreement. The Constitution, just like any piece, the Constitutional Convention was effectively a legislative body. It was a group of representatives. And they each had their own views. And to suggest that what was produced was something that represented one individual meaning, okay? It's not how legislative bodies work. The Constitution, just like any other law, is a product of compromise. What could they all agree on? What was the lowest common denominator that they could all agree on? They may have, right, used language, intentionally vague language, right? There may be language that's vague, but the original intent was to be vague, because that was the only way they could get sufficient numbers of agreements. Ultimately, the Constitution had to be agreed upon by the states, the 13 states, the colonies, okay? It's a political event, ratification. And so the idea that there is an actual meaning as opposed to many meanings, and that the original intent wasn't to have many meanings or be open to subject to interpretation later on, or differing views, I think cuts off history and does it a disservice. It doesn't acknowledge the reality. And so, you know, I do think it's worth taking the time to read Heller in the light of what has become the dominant mode and theory of judicial interpretation currently, both on the Supreme Court and in the federal courts and in most of the state courts, and whether or not that's its value and whether or not it's the correct way to go, and whether or not it's the best we can do in terms of providing for an analysis. I don't know. The other thing I do want to look at is, you know, I do want to take a slightly different view in terms of whether or not the collectivist view or one view of side of Heller views the individual citizen as sort of a good participatory person, and the other side of Heller is the view of the individual as sort of feckless or dangerous and apart from, separated from the government. Because, as Professor Diamond notes, one of the complications of Heller is, and I would absolutely love to hear Professor Diamond's views on it, because I think it's perhaps the most interesting question of Heller, was the one that first occurred to me when I first read it, which was, is this going to be incorporated through the 14th Amendment and made applicable to the states? Remember, that's not addressed in Heller because Heller is in the District of Columbia, which is a federal territory, so the first 10 amendments apply directly. Okay, there is no incorporation doctrine for the District of Columbia, because I know my practice that there is in the states. So that's an interesting, I think that that's one of the most interesting questions. But, for example, having experienced both enforcement of the District of Columbia handgun laws here in handgun laws here in New Orleans, both generally and the immediate aftermath of Katrina, I doubt that Heller itself or any interpretations of Heller or subsequent opinions are going to provide are going to provide a resolution to the type of dichotomy that Professor Diamond suggests. Because in fact, for example, I don't think I would strenuously argue that Heller is never going to protect against the situation that arose in the immediate aftermath of Katrina. Okay? There is absolutely no question that both sides, all 9 justices in Heller, agree that there can be regulation. You can prevent felons, you can prevent the insane. The First Amendment. Your First Amendment rights cannot be infringed. For those of you who have had, it is absolutely clear that time, place, and manner restrictions are permissible under the First Amendment. It would be inconceivable that time, place, and manner restrictions would not be permissible under the Second Amendment, and Heller acknowledges that. Can't have it in school, around schools, government buildings, going onto an airplane. Can anybody imagine a court throwing those out? I can't. Can I imagine a court saying that it is beyond the power of the government in a state of emergency, in a declared by the executive branch state of emergency, for there to be restrictions on possession of weapons? In a very narrow way, only during a state of emergency, during the briefest possible period, like we have in hurricane evacuations, like we've just had in Gustav, right? We have dusk to dawn curfews. People are not allowed to freely move about the city. I was here during Gustav. I had one of those little special placards that I could get through, and I had to show them in my ID to National Guardsmen and armed National Guard and police officers. I cannot imagine that kind of restriction. So it's not going to prevent that. Okay, similarly, I can't, it's explicit. And what I see is that the way gun laws are actually used is very different than I think than it's, and that's one of the things that comes out from DC versus Heller. You have to recognize DC versus Heller is a manufactured case. Okay? Manufactured by people wanting, not that there's anything wrong with that. I manufacture cases all the time. There is nothing wrong with lawyers creating a situation to address a constitutional issue. Okay? I don't mean that in a pejorative sense. Okay? But it is a manufactured case in the sense that it is divorced from the real world. Right? You have somebody who is trained and licensed to have a weapon, who is the ideal model citizen, the citizen that Professor Diamond, this sturdy, rugged individualist who's there to protect his family and protect himself and be a partner with the police. That's not the reality of gun laws. That's not how gun laws are enforced. Okay? And that's not what happened after Katrina. That's not what happens in the District of Columbia, and that's not what happens here. In point of fact, okay, and this may be an area where Professor Diamond and I actually agree. In point of fact, what the way gun laws are actually used is that the sturdy, rugged individualist is allowed and will be allowed under Heller. Justice Scalia is never going to give up his gun. Dick Cheney's never going to give up his gun. Okay? Justice Thomas is never going to give up his gun. Okay? The citizenry who is deprived, and as if you read Heller, they talk about this. They talk about the immediate post-Reconstruction era. Right? Because there's a lot of gun laws in the post-Reconstruction area to prohibit who? Blacks, newly freed blacks from possessing guns. Okay? Because the white citizenry, this is when you have the Klan and lynchings. Okay? That's why all of this, a lot of this prior cases, as Professor Diamond so eloquently told you about, and accurately. The litigation was in from the post-Reconstruction area till about 1920 or 30. Okay, that's where that is. And the way gun laws are enforced now is if the police view you as part of the establishment, okay, you have a right to protect yourself. Okay? You have a right to have a gun. Guns, in point of fact, after Katrina, guns get taken from poor people, from people who look like they're not, like us. Professor Diamond isn't going to have his gun taken from him. I'm not going to have my gun taken from him. Okay? The people who are going to have the guns taken from them are, and we're also maybe the ones least in need of protecting ourselves. People who live in housing projects, people who are poor, people who speak a different language, who have a different color skin, who look in any way different from the rest of us. Immigrants, poor, okay, on the edges of society where it actually is dangerous to live in daily life. They're the ones that get deprived. They're the ones that get arrested under the laws. They're the ones that get prosecuted. I recall recently a recent case that we had in New Orleans at the public defender's office where there's a 17-year-old African-American young man. It's about 2:30 or 3 o'clock in the morning, okay, on Canal Street on a Friday or Saturday night. I think it was a Saturday night, 2 or 3 in the morning, so Sunday morning. And in Louisiana, it is legal to carry a gun openly, sticking out of your belt. Everybody can see it in your holster. That's legal, as long as you purchase it legally and you don't have a felony conviction. It is unlawful to carry a concealed weapon. So if it's under your shirt, near your belt, concealed. That's illegal. Okay? Walking down the street with the gun sticking right out, the police stop him and take his gun. They run him to see, because they think this is not a safe situation. Okay, probably an accurate assessment. But they then stop him and take his gun, and nothing turns up, and they just send him on his way, and they tell him he can pick up his gun on Monday, but they don't want him walking down the street with it. Okay, and it later turns out, later they find a felony conviction that made it illegal for him to carry the weapon off of the serial number by tracing the purchase and then running it through the actual computers and getting it from another jurisdiction. And so that's how he gets arrested for felony with firearm, and ultimately the case gets tossed out because the seizure of the gun was illegal in the first instance, because they had no basis at the time for seizing it. But that's how the reality of how gun laws get enforced, and that's the reality of what time, place, or manner regulation and restrictions, how they ultimately, I believe, would wash out and end up under Heller and under its analysis as it applies. Very similar to what we have going on currently in voting rights. Felons in many places are disabled from voting. Thankfully not in Louisiana, at least not permanently. But felons are disabled from voting. And so what the government does, and what those in law enforcement at various time periods do, is you try and get as many people charged with felonies and convicted of felonies as you possibly can, so that they are now without their civil rights. And I really believe, it fits in with one of my firmly held beliefs, which is that the use and enforcement of the criminal laws in our society is actually the current civil rights issue of our era. And as we know, and as those certainly Federalist Society members know, the Second Amendment right to keep and bear arms is a civil right. That's a civil right just as your other civil rights are. Just as your right to vote, your right to First Amendment free speech, freedom of religion. And so what happens is that I think that essentially it doesn't go along the lines of whether or not individual people who are granted the right, deprived of the right, are the sturdy, rugged individualist defending themselves, or the feckless, dangerous person, the criminals, the police and the criminals, but rather it becomes a matter of sort of class and your place in society. And again, this, you might be confused, well, okay, what does that mean about where Senator stands on this? And what it means is that there's this dichotomy, right? On the one hand, it shouldn't be a right that, if it is a right, then it shouldn't be a right that only the mainstream of society gets to have, as opposed to those on the more fringes. On the other hand, it's not clear that the absolutist version is absolutist and therefore gets you where you would like it to be. And so it makes me conflicted over it. I promised to be shorter, and so with that I'm going to stop my comments and invite you all to ask questions, but I want to get the first question out, which is I want to hear what Professor Diamond thinks about the incorporation. I do think that that's
Well, let me get the
next
first
issue.
answer then, and I have to say that as Steve began to speak, I felt a little bit like Barack Obama must have felt when John McCain was saying at the Al Smith dinner that Obama was going to be so funny that he just meant no pressure whatsoever on Obama. I believe that the Second Amendment right is going to be interpreted eventually as a fundamental right that is incorporated. I think that the framers of the Second Amendment were very much 17th century Englishmen in their thoughts about the right to bear arms. These were the people who engaged in the Glorious Revolution and who had the right to bear arms. Admittedly, a right that was subject to regulation, but they had this right to bear arms ensconced in the English Bill of Rights. The framers of the Second Amendment, I think, were very much of one mind. They were in accord with Blackstone. If you look at Blackstone's commentaries, the first volume, the first book, the first chapter, starting at page 139, what you see is that Blackstone sets out what he calls absolute rights. These absolute rights are divided into two categories. One is principal rights, and second, auxiliary rights. The principal rights are of personal security, personal liberty, and the right to private property. These auxiliary rights, he says, are rights without which the citizen, actually the subject in that case, would be unable to protect the principal rights. And among those rights, the fifth among these rights is the right to bear arms. Blackstone thought that these rights were fundamental. I think that the framers of the Second Amendment thought that these rights were fundamental as well. And even if the framers of the Second Amendment didn't think the right was fundamental, I think the framers of the 14th Amendment thought that this right was fundamental. Some of the best language that we have in the 38th Congress as they debated the 14th Amendment, some of the best language that we have that goes to incorporation are members of the House of Representatives talking about the Second Amendment. It's very clear that they thought that this Second Amendment right to keep and bear arms would be very, very important for the freedmen to be able to protect their freedom and for them to be able to protect their right to vote, and so on and so forth. The third thing I'll say on this issue is a story which I think says wonders. There are hearings, I think before the House of Representatives, about two different incidents, one someplace in Alabama, I can't quite remember where, and another one in Vicksburg, Mississippi. It's both in the Reconstruction. Black Republicans with their weapons, get together with their white Republican friends on election day and they say, we're ready to go vote. The white Republicans say, oh no, voting is a majestic thing, it's a wonderful thing, and you don't want to sully it by bringing your firearms. Leave your firearms here, we'll get them when we come back. The end of the story is the white Republicans and the black Republicans were fired upon, many were killed, and they never got to vote. Vicksburg, Mississippi, perhaps being, dare I use the word, armed with knowledge of what happened in Alabama, black Republicans came to white Republicans at the meeting place. They prepared to vote. The white Republicans said, leave your guns here. Voting is too fine of a thing to be armed when you do it. The black Republicans kept their firearms. And when fired upon at the voting place, the black Republicans fired back, and they all got to vote. I think that is a marvelous story, speaking to what I think is so very important about the right to bear arms, that at the far end of the spectrum, and admittedly, it's an end of the spectrum we don't want to see, but at the far end of the spectrum, the right to bear arms is that which protects our personal security, and it protects our rights, and our personal rights. It protects our property. Now, I do want to suggest that one thing that Professor Singer said, I'm not sure I'm going to buy, that this was a manufactured case. I'm not sure I buy that. Heller was an establishment kind of guy. He had he bought this gun outside the District of Columbia, and he asked essentially to register the weapon. He was not able to. But there were two other plaintiffs who don't make it to the Supreme Court because their cases get dismissed along the way. One is this old black lady in Southeast Washington, this little old lady who moves into the neighborhood. It turns out the neighborhood is infested with, dope dealers and the like. And she was the one who would call up the police and say they're selling dope on such and such of a corner. And when the bad guys found out about this, they broke into her house and attempted, to do her in. She wanted a handgun. She couldn't get one. The other of the three people was this gay fellow from California who had been threatened with gay bashing on at least a couple of occasions. His mother gave him a firearm. She said, take this. If you ever get bashed, you want to be able to use this to protect yourself. He moved to the District of Columbia. They wouldn't register his weapon. Neither the woman nor this other fellow had their denial in writing. But Heller did have the writing. It did have it in writing. Was it manufactured? It was a public interest law firm that took this on, but the lawyer who did it actually did it on his own time. He didn't do it on behalf of the organization. He knew the gay fellow. I'm not at all sure that this was manufactured in the sense that there were a group of lawyers like the NAACP Legal Defense Fund looking for clients in order to push the outside of the envelope. Two of these three actually came to the lawyers. So I'm not sure that this is manufactured, but I don't think that detracts from much of what Professor Singer had to say, that in our society there are those of us who look like we're safe, and we will never be challenged in our right to bear arms, unless we're doing something wrong, in which case we'll get challenged anyway. There are others of us who don't look like we're upstanding citizens. And it's those of us who don't look that way, whether we're in the wrong neighborhood or the wrong color or the wrong language, those are the people whose rights will be challenged. And I think the Heller case goes to the question of under what circumstances we are willing to protect the simple right of the simple person to protect his or her own liberties via arms. I think that's the fundamental question that Heller puts. I do think it will be incorporated into time. As for what the balance is going to be, what the test is going to be, I don't think it's going to be rational basis, but I'm not exactly sure what it will be.
Questions, anyone? Please.
This is about gun control and how it affects the arguments that you've been talking about with Heller. But if guns as property, if I buy a new car and I sell it to you, sir, we have to get that notarized and registered. If you sell it to Professor Singer, it has to be notarized and registered. But if I buy a new gun, sell it to you, nothing's really needed. Is that state by state? You mentioned registration in the District of Columbia. And I guess the broader question is how that trade in arms, that it, as a gray market and perhaps black market, affects what we're talking about. That's how the bad guys get guns, according to popular theory, correct?
Yeah, and I guess my interpretation of Heller is that I would find it hard to believe that, for example, registration requirements or requirements like, as you discussed, like akin to like selling a car or whatever, requiring documentation. I find it hard to believe that that's not going to withstand whatever. I agree with Professor Diamond. I agree that it's going to be incorporated. It's going to be fundamental. And I agree that the key is what the test is going to be on a rational basis, given that it's the Second Amendment. It's not just a statutory law. It's a fundamental right. So I think that that's true, but it's hard to imagine that whatever the test is, that kind of restriction, remember with the registration requirements in DC amounted to an outright ban. There is no question about that, that essentially, unless you were grandfathered in, unless you owned a gun, basically at the time that DC was incorporated, DC incorporation, which was 73, 74 when it happened, unless you had a gun licensed before then, because obviously as time goes by, there's going to be fewer and fewer that grandfathered in. The registration requirements were not like that. Registration requirements were essentially you can't register. It was a de facto, if not de jure, outright ban.
Yeah, that characterization of the DC ordinance is certainly correct. It amounted to an outright ban. I, for one, would suggest that, well, I really cannot imagine that most gun control statutes that we have and most gun control ordinances that we have will survive. I'm sorry, I said that wrong. I find it hard to imagine that most of them, in fact, the overwhelming majority, will not survive. I think what will happen, however, is that we will have a different discussion in the judiciary from what we had previous to Heller and previous later to incorporation. I think that the balancing test that we use is one which will have to take account of the political theory that underlies the Second Amendment. And the political theory is the people are virtuous, the people should be depended upon, can be depended upon to help safeguard order in the society, and that the people should be trusted to guarantee their own security in the society. But having said that, I mean, we'll take account of that, but having said that, I doubt very seriously that registration requirements and licensing requirements and the like, I doubt very seriously that they're going to be put down. But here's something that I'm less sure about, and that is more of a stretch. I have argued in some of my writing, and I think this is accurate, that one of the reasons that the framers insisted upon the Second Amendment, that one of these reasons was so that the individual armed citizen and collectively armed citizens would be a hedge against governmental tyranny. Now, there is an argument, therefore, that for the government to know exactly where all of the firearms are is to lessen the intensity of that hedge. Because if the government can come and take away our guns, and they can only do that if they know where they are, then the government is free to be tyrannical. I think the argument that renders that argument not successful is that statistic, that there are more guns in the country than people, and that over half the households in America are armed. And I think given the widespread character of the American citizen as an armed citizen, it's very hard to imagine that government would be able to disown everyone, even if it intended to, and it were able to know where the weapons are via registration requirements. But that, again, I'm not sure that argument's going to make it, but that's the only argument that I can think of that would go to render registration arguments, rather registration regulations unconstitutional. And I don't expect that argument would work.
Anyone else?
Yeah, has any statistics shown that strict gun control has actually reduced gun crime? I mean, in these cities that have these real strict gun laws?
I think it's so, because crime is so complex, and because handgun regulation is itself also a complex proposition. I think it's virtually, it's one of those things that you can marshal statistics either way, but the statistics, it's like the book How to Lie with Statistics. Because the fact that there is extraordinarily low homicide rates in Europe, where there's very strict gun control regulations, prove that gun control limits regulation, or is it that, or what's the interplay of a less diverse society, higher overall mean income, a different educational system, maybe a better educational system. I mean, there's so many factors that affect the crime rate, right? I mean, crime is primarily driven by two things, and it's, at least I believe it's driven by demographics. How many young males do you have between the age of 18 and 35 in the society? When that number goes up, crime goes up. When that number goes down cyclically with booms, baby booms and not, when that number goes down, crime goes down. The other thing that it correlates very well with is economic circumstances. Better the economy, crime goes down. Okay, worse the economy, crime goes up, right? And those are sort of, things that have, so many other things have such a much stronger influence, right? For example, we talked about the black market, right? So the DC handgun ban or regulation, right? Does it, it's impossible to tell, right? Because weapons flow freely across. DC is a relatively small area. It's a small urban area bordered by states. There's interstate traffic, and so I think, and I think it's one of the reasons I think that you see on neither side in Heller an effort to even try and make that argument one way. One is that that's essentially a political argument, but two, I don't think it gets you anywhere.
Well, I'm in agreement with what Steve has said about the statistics. You can find anecdotal studies. You can also find broader studies by people who either understand or pretend to understand statistics much better than I do. But the anecdotal studies that I find most interesting are in those jurisdictions like Florida. Florida has universal concealed carry. And what happened after Florida allowed for that was that incidents of robbery, burglary, and the like went down, except except in areas clearly identifiable as tourist areas, and except, people, carjackings went way down, except against rental vehicles, because those would be tourists. I mean, I do think that there's something to the notion that the rational person who demands criminal activity is going to try to minimize his or her cost. And having a victim who is armed represents greater, not lesser costs. And we do have studies that suggest that when we've allowed for more widespread, at least the potential of more widespread armed individuals, then we've had a negative effect on crime.
I have a question about the duopoly, where only the police and criminals would have guns. But then the whole in that logic is that, according to the Supreme Court, the police are not under a positive obligation to protect the citizens.
Yes.
So what's the answer to that then?
Oh, I think the answer to that is that on a policy level, we don't want a duopoly of force. I think on a policy level, we should presume that the citizens, just as they are virtuous enough to handle free speech and freedom of religion, the citizens are virtuous enough to handle a right to bear arms so that they can protect themselves. I think on a policy level, that makes perfect sense to me. And that argument is I think, given more force due to what I like to call the mini Armageddon. You know, the War of the Worlds represents Armageddon, and it represents a great big Armageddon. But we have mini Armageddons all the time, when the police are either not there to protect us, or they don't want to be there to protect us. In Hurricane Katrina, they weren't there and they didn't want to be there. Sometimes they were in Houston with their families, or hiding out from the bad guys, or they were surrounded by the water and they couldn't protect us. But the bad guys were there, and they were stealing stuff, and they were raping women, and they were committing arson. And if we didn't have weapons to protect ourselves, then who was going to? Similarly, look at the riots after the state verdict in who's the fellow who was beaten by the police? Rodney King. Think about what happened then when there were riots in South Central LA. Now, the victims of those riots were Hispanics and Koreans, by the way. This was mostly black people rioting, expressing displeasure with that verdict. But the police were nowhere to be found because the police didn't want to go in and face that riot. And for me, the image that certainly speaks to me were television images of Korean or Korean ancestry people with their firearms outside of their stores, protecting themselves and protecting their property. The Second Amendment is it ought to make us uncomfortable, I think. And talking about how we can use firearms to protect ourselves, this even makes me uncomfortable. And I'm a Second Amendment proponent. And the reason it makes us uncomfortable, the Second Amendment is not there so we can shoot targets. It's not there so we can shoot animals. The Second Amendment is there so we can shoot people when the situation calls for it. When the Canadians come rushing across the border and invade the United States, and Uncle Sam needs our help, it's to shoot the Canadians. When our neighbors decide that they want to hold a necktie party, and they want one of us as the guest of honor, the Second Amendment right is so that we can shoot people. Make no mistake about it, this right of self-defense is one against people. And it ought to make us uncomfortable because it needs to be used responsibly. And there, I think, is the purpose of government, is in putting regulations to us which hold in high relief our obligation to use this right responsibly.
I know you want to go, and I know time's short, I do want to get my 2 cents in on this one. And the difference I would have is that I don't see a duopoly. I see a triopoly. I see 3 sides. I see the police, the criminals, and the mainstream society, your solid citizen, Heller. Okay, and so I see those people will have gun rights and that your honest fringes will not. what are the images, for example, I don't see, what I see guns, for example, after Katrina. I don't see the individual African-American person, Mr. Diamond, you know, in a suit and tie, who's respectable or whatever. His neighbors want to have a necktie party, and they come to get him, and him using it to defend himself and protect him from that. What I see is honest, poor, hardworking citizens of New Orleans going across the Crescent City connection to try and get to food and water, and the police and private citizens shooting at them. Okay? That's what I see. And I don't think Heller protects you against that. I think what happens under Heller is that, again, the triple actually has the guns, and the people who need exactly what happened during Reconstruction, you know, during lynchings or whatever. Sure, there were gun laws for African American citizens to be able to exercise the right to vote, but primarily, okay, what ended up happening and the way this ends up working out, the reality is, politically, is, right, the Donziger Bridge. The poor African American person trying to get across the bridge to get food and water, getting shot at, okay, and not the people uptown.
All right, well, thank you guys very much for coming.